I was going to say good morning, but I guess it's afternoon already.
Yeah, sneaked on us, yeah.
To the chair and to the committee, thank you for the opportunity to speak to you about AB 412. My name is Henry Plum, and I'm a practicing attorney, but I'm here today on behalf of the Children in Law section of the State Bar and testifying in opposition to AB 412, Foster Parent Bill of Rights. You've received a copy of our written testimony, so I won't go through that in detail, but rather I'd like to highlight some of the concerns with the legislation that we see would be problematic for practitioners. And I certainly welcome any questions from the committee. Let me begin by just pointing out that the Children in Law section recognizes the valuable function that foster parents play in the child welfare system, and we could not function without the role of foster parents. However, when we take a look at this particular bill, there's a couple of principles. Number one, we don't believe it's necessary. Why? Because many of the laws, the current laws and regulation that the bill addresses are in the law already. For example, foster parents are required to get notice of all hearings. They are required to participate, if they choose to, in permanency plan hearings. We've been talking about permanency plan hearings and other litigation. In the counties that I represent, foster parents have received and always receive copies of permanency plans. So that may be a difference in some counties, but certainly not within my experience. Foster parents have a right to request a hearing and have a right to challenge, hire their lawyer, have hearings, they can appeal rights. So many of the rights that are asserted in this bill or raised exist already in the legislation. So we don't believe it's necessary to have that, especially if the Bill of Rights goes beyond what is allowed in the statute. Then you have an inconsistency, and that leads to problems and litigation, et cetera. The second principle, I think, that reason why is that the lack of ambiguity, clarity, and confusion. When you have one party, and in this instance, the foster parents are not legal parties to the proceedings; they are created by statute. When you have one party having a Bill of Rights, but you don't have a corresponding Bill of Rights for children or Bill of Rights for parents, that creates an imbalance and creates ambiguity and leads to litigation. Because the question is, how do we understand that? How are the courts to apply that? So that is one of the problems, leading to more litigation. Thirdly, it is redundant. We've talked about information that foster parents have regarding children. The statutes currently require, and I won't give you the site unless you need it, the statutes currently require that foster parents are provided all information regarding the child, medical, psychological, emotional, developmental, any information that they need in order to provide care for that child. That's in the statute already. Now, if counties are not applying that, that's a different issue. The law is there. And certainly the Bill of Rights references it, but it's there already. Where there's an inconsistency is it contradicts the statute, where the Bill of Rights also requires that information concerning the parents be given to the foster parents. Psychological, psychiatric, AOTA, domestic violence, etc. And there's a concern because that's a privacy right. And that information should not necessarily be shared automatically. And it presents a problem. I've been involved in litigation from counties, representing foster parents, et cetera, and I've seen these. And where information is given to one party that is damaging to the other, that is going to come out in litigation. As a lawyer, I can tell you that we're going to do that. And there's a concern about the privacy rights of parents when they are dealing with the courts. And we do have privacy requirements in the statute, but the reality is that doesn't prevent the parties from going forward and bringing it into court. So on one hand, it's redundant for children, but on the other hand, it contradicts the current laws of confidentiality and privilege for parents. And so we're concerned about that. Another one, and which has been raised already, is it's inconsistent with the federal and state law concerning placement preference. Now, the reference was already to ICWA, the Indian Child Welfare Act, in terms of the placement preference, but this Bill of Rights creates a placement preference for a foster parent who had a child at one point, and then the child was returned. We know that under Families First and under the litigation and under the legislation, that placement with relatives, for example, is a priority. Well, now you've got a conflict, and we're creating a conflict in the law, which leads to more litigation. And so I think that placement preference is problematic with both the federal and state law. And finally, it's the potential for unintended consequences. The question is, when you have ambiguity, when you have a child, when you don't have a child Bill of Rights and a parent Bill of Rights, but you have a foster parent's Bill of Rights, that's going to lead to litigation because of the ambiguity. As a lawyer, that's part of what we do. We litigate issues. So I don't think the intent here was to create more litigation, but to provide more clarity. So at this point, the way the bill is presented, the Bill of Rights, the children-in-law opposes it in principle because of what it states. I think there may be resolutions as offered by the state, ways to get around this. Certainly a statement about what interests foster parents have, but to put it in the statute the way it's in this legislation is problematic. And for those reasons, the children-in-law opposes for AB 412, and I'll take any questions.
All right, thank you very much. You brought up the fact that there are already laws on the books to get, information, but some counties might not be providing that. So what's the recourse for the foster family? Do they report it somewhere? Do they have to retain legal, counsel or?
Well, they will get notice of the hearing, right? That's required by statute, and I'm not aware of any counties where they simply ignore foster parents don't give. So they are in court, and they can then raise it with the court. They are also allowed to either, if they want to speak, give oral testimony, they can give written testimony, so they can raise it with the court saying, Judge, we're not receiving it. And at that point, the county then is going to have to deal with it, Okay. But I think that's the immediate result, and the judge ordering the county, you're going to see results.
Okay. Any questions from committee members? All right. Thank you.
Thank you.
All right. Registering against is Lynn Davis, State Bar Child Law Section. Registering for information only, and she's put information out, was Emily Caddington of Wafka. Joe registering against, Joe Stroll of Menominee Tribe. Ho-Chunk Nation registering against out of Black River Falls. Registering in favor, State Senator Andre Jock. And registering against, State Public Defender Adam Plotkin. All right, that, see how surprised how quick we went today? Kind of just keep your calendars. We'll digest some of this for executive session for any of these bills. So with that, I will adjourn the committee.